you know, part of my job is I got to be fair to the people. I got to be fair to you. And so and if I feel that something's not fair, I'm not going to head down that path. That's my job. Okay. And when I'm saying that, young man, you need to start listening to folks that have law degrees. You're listening to somebody else.
A defendant is offered a deal that could remove multiple charges from the table and potentially keep convictions off his record, but he still refuses. Then the judge discovers another case and a probation hold that could completely change the situation. As the defendant tries to explain why he wants to move forward, the judge stops him and makes one thing clear. He needs to understand the consequences before making another decision. With multiple cases, a no-bond hold, and conflicting information about his bond, the hearing takes an unexpected turn. Let's start the case.
Good morning, Robert Jacob on behalf of Donald Smith, Jonathan Smith.
All right. Okay. And this date and time set for preliminary examination, both these matters.
There was a previous offer made to my client, which I took to my client to the jail, and I asked him again if he wanted to take advantage of a possible higher plea. Mr. Chevlo.
Judge, I did make an offer to the defendant as an alternative. He can plead, and I apologize. I don't know.
I got it here, Alex.
Thanks. It would call for, in case number, so either would call for Mr. Smith to plead guilty to discharging a firearm at a building, the 10-year max. In case number 25F21637FY, with an agreement to sentence under PIDA, the Holmes Youthful Trainee Act. And my office would then dismiss the remainder of the charges, which are an R&O, a 2-year max, carrying a concealed weapon, 5-year max, and possession of a firearm by a prohibited person, also. Or Mr. Smith could plead guilty to resisting obstructing an officer, a 2-year max, in case number 25F21637FY. And I wrote it as carrying a concealed weapon in case number 25FB2506FY. With an agreement to sentence under the Holmes Youthful Trainee Act and dismissal of the remaining charges, which were discharging a firearm at a building and possession of a firearm by a prohibited person. It's my understanding that Mr. Smith is not interested in that.
Mr. Smith, you and I went over those proposed plea agreements, right?
Can I?
That's weird. That's such weird agreements.
Whether you're client, I don't know. Mr. Killowell, did you voir dire him in the context of a probation violation that he has out of Wayne County?
I wasn't aware of that, no.
Okay. So my understanding is he has a probation violation. I'm not clear what for, out of Wayne County.
I may be able to advise to the
Go ahead.
court. At the time of both of these offenses, it is my understanding that the defendant was on bond from an Oakland County case number 2529266FH. He had pled guilty, or he had pled, it says guilty plea on the ROA, the Register of Actions, to unlawful driving away of a motor vehicle on, he was found guilty on September 4th, 2025. This incident date is like the 30th.
Pardon?
The incident date on these cases is the 30th
Of September?
2025.
But he was
He
sentenced?
was sentenced in November of 2025 for the UDAA on November 6th. So I don't think this would necessarily be a probation violation, but I don't know if the hold is just pending figuring out what's going on.
Well, the information that we received is that it's a probation violation.
Okay.
And with no bond. But
The case that he's on probation in Wayne County for is the Oakland County case.
is the
Yeah.
Oakland County?
It looks like he got
That is-
transferred to Wayne County.
What are you doing for? CCW, I don't know, you pled in Wayne County,
On a HIDA.
CCW.
Oh, I didn't have that.
When that was? Or,
Did he just say he had another CCW?
And I didn't want to cause any confusion. I just wanted to make sure that whatever conversation he had with your client about a possible resolution here was taking into account everything that he has. I was not aware of, I don't think I was aware of the Oakland County issues. We were just informed that he has a no bond hold in Wayne.
Judge, my client, I believe, did tell me at one of our visits at the jail, but nonetheless, he's not interested in the offers or anything like
Right, I just want to make sure that it needs to happen, because I don't know what that's about. I can't see it to say why he has no bond on that case.
Careful what you say, but if it's regarding that, what are you saying? Stand up first, you're talking to Joe.
It's no bond because if I'm going to be charged with CCW and shooting into a building, then that's of course violating my probation. So even if I take...
Right, no, I hear you, but is that the reason it's no bond is because of these cases?
Yes.
I see. Okay. So the deals you offered, that doesn't even make any sense. So counsel approach, please. Record should reflect we've had a bench conference. I realize that there's been an offer extended. I realize what the defendant is saying now, okay? Young man, just listen to me for a second. And why I asked your attorney whether or not he knew about that is because that the Wayne County matter can have certain implications for you. Okay. But because your attorney doesn't know about that, he wouldn't have had reason to necessarily investigate what those implications are for you. Okay. And because of the way that the statute, the HIDA statute reads, as I see it right now, without going into all of the way things play out, you could end up with a number of convictions and no HIDA. Okay? I don't think that's what you want, right? And that's what I was getting from what you said before about why you may want to do this. It may be, okay, and your attorney's going to check into this, that, and I'm just going to give you a hypothetical, okay? I'm not saying you're going to do this or anything. That if there's a plea in this case, or in these cases, you could maintain a HIDA here, but then lose that one in Detroit. Then the question becomes, what happens to you? What's the probation department going to do? Okay? Otherwise, what you could do, you go through and fight these. If you get convicted, you would get, chances are you may not get HIDA on these, and then you lose that one there, right? Which would not, I know you don't want that. And I've just given you sort of a thumbnail of it. What I don't want to have happen is for you to be making that decision without a full discussion with your attorney who just found out about this. And he's going to at least have to make a phone call to try to figure out what's going to happen and when. Yeah.
I don't want to make a waste of time. I don't agree. I don't.
What?
I don't want to make a waste of time.
It's not a waste of time. He's got to advise you.
I don't want.
He's got to advise you.
What the judge is saying, you can fight this case, but if you lose it, you may not. Detroit, you just saying that, you make a phone call, see what Detroit's going to do. I know you want to fight these cases, but the judge wants to make sure you know the ramifications of Detroit decision in case you lose.
So I can have a fair chance.
That- What?
So I can have a fair chance and know what's going on.
Exactly. I mean, that the problem is this case came back, we set everything real quick, but then there's this other stuff out there. And, you know, part of my job is I got to be fair to the people, I got to be fair to you. And so if I feel that something's not fair, I'm not going to head down that path. That's my job. Okay. So what I'm going to do, we can consider it, I'm going to find good cause given all of that. I'm going to adjourn the prelim today. Just listen. And here's the reason why. If I thought that was going to penalize you, I wouldn't do it. Problem is, you're not going to go anywhere anyway because you're on a no bond hold. They're going to keep you here. So if I thought it was going to keep you in, remember, I'm the one that gave you the bond I gave you, right? So I'm not trying to keep you anywhere. But I got to make sure that you know all of this stuff. Yeah.
If my mom talked to my kiddo, and if this makes it past prelim, then they're gonna come get it. But my PO is being fair with me.
Well, I don't know that they're going to come get you.
I'm telling you, she said that my PO said
POs could say a lot of things about coming to get you. That's not necessarily whose decision it's going to be. All right. I'm just telling you. Young man, here's the thing. You're rushing, trying to make certain decisions. You got a brain, you need with your attorney to try to figure it out. I understand your mom may have had the conversation. I'd feel a lot more comfortable if your attorney had the conversation about what they intend to do. Because
Forget about the kids. We're never off again. You get convicted. He's worried about what the county. You're not going anywhere because when county says. Right down to mom's phone number. And I will.
that's why, can I just say this? One of the reasons you're still here, because remember, the bonds I gave you, you could post and get out, right? And you have to ask yourself, why are you still here? You're still here because of that Wayne County poll.
right.
You're not going anywhere.
Right. They said. Sorry.
Go ahead.
They said if my PO said this directly, if this is like made over to circuit court, then she's going to come get me. I'm gonna be violated for probation, and that's of course not making a deal as well. But I said, can she be fair? Can she please let me make it past preliminary exam? And if the charges are dropped, and she's not violent, she said that she would.
But she didn't tell you that.
She told my mom that. My mom told me.
See, is your mama?
Your mom wants to know the phone number.
Yeah, I still don't get that part because even if he,
Judge, while we're waiting for, there's one other recommendation. You were gracious enough to give this young man a PR bond. We all expected him to get out.
Released. I'll set it. I'll just
$100 bond?
Yeah, I'll just make it $100 bond, so that he's getting credit.
That's
You understand that, young man?
That's on case 25.
This is why you need to, you've got a very good, very experienced attorney. You need to listen to him. Okay? Because I think you're making decisions based upon what you see and not understanding everything. All right, that's what I'm seeing. So the reason that he's asking for the bond, I gave you a PR on the one case. Since you could be released on that case without posting it all, right? You're not getting credit on that case for the time that you're in. So what he's asking me to do is to give you a nominal bond of $100 so that you at least are getting credit while you're sitting there. Follow that?
To Wayne County? Is that possible?
I typically don't get involved in that. So it's usually that they won't release him. Wayne County's not going to come and get him because they know where he is. They put their hold in. Once we're done, then they're going to come get him. We done. I don't know where in the process they're looking at trying to do that.
Would you, if there's any movement on this case, when you kind of let you sit here?
They're not, because they can't. And when I'm saying that, young man, you need to start listening to folks that have law degrees. You're listening to somebody else, right? And you need to start listening to that man sitting next to you about what you should do next. Because right now, as I see it, and what you're telling me, you're making all the wrong calls. I gave him the 25 personal on the
Bible.
I'm going to change that bond to $100 cash as surety. I'm going to adjourn the preliminary examination to February 3rd, 2026 at 9 a.m. Let you check all of that information out. And I don't have a problem going forth, but let him do it with everything in front of him as to what's going to happen. Right?
Adjourned to February 3rd, Judge, 9 a.m.
9 a.m. before me on both cases.
Oh, they're two separate cases.
Yes, sir.
Are you able to make the the change to the $100 effective last week, Thursday, so he gets all his credit? It's like it's 4 days, but it's 4 days. I don't know if it is, or we just have to fix it later.
Judge, this young man is saying he gave PR bonds on both cases. I don't recall that.
No, I didn't give him a PR on the
50,000, 10%.
right. I gave him. Well, no, I see it. I did. I gave him a PR on both cases. That's so he shouldn't even be here right now.
I thought you had left the 50-10%.
No, I'm looking at the Caro, and it was $25,000 personal recognizance on that one, and on the other one, well, no, something's wrong here. That's not right. I think they got the wrong.
I thought you
They
said
got the wrong amount. What do you have on that bond? The 1637 should have been left the same because you said that you could post that one. That was the one I had already used. The new charge that came up was it was the court's intent to do the PR. Correct. And so on 1637, that bond should have been the 50,000 cash surety, because he was gonna be able to post that. Right? In the other case, what I'll do is I'll increase his bond to $100 cash surety, and I'll do the bond to January 8th, so he'll get the 4 days credit.
1,000, or is it?
It's 50,000 cash surety.
No, you took away the 10%?
It was, I don't think it was 10% before.
Yeah. What, that's what you raised it for?
I just want to make sure I hear you, Judge.
Hang on a second. Let me just,
From Christmas, the 23rd.
let me make sure, because it should have been a bond form in here. Will be the 10% bond on that one. The other one I'm raising to $100 so they can be credit retroactive to the 8th. Yeah,
I can't post that, the first bond. Sorry.
No, don't be sorry, you can't post it, give him credit, you should not post it. You know what I'm saying, that's how bond works. If he says bond. You understand what posting bond means?
That 50,000, 10%.
Right, you can't do that. So in return, you get all, while you're sitting in jail, you get credit, but you can't post it.
all right. Thank you. We'll see you in a couple of weeks after they check on everything, young man. Thank you.
This hearing involves Mr. Smith, who is facing multiple charges, including discharging a firearm at a building, carrying a concealed weapon, and possession of a firearm by a prohibited person. The prosecution presents plea options that could result in some charges being dismissed and allow sentencing under the Holmes Youthful Trainee Act. But Smith is not interested in accepting the offers. The situation becomes more complicated when the court learns about another Wayne County matter and a no-bond hold connected to his probation status. The judge realizes Smith's attorney may not have had all the information needed to properly advise him. That changes the discussion completely. Instead of rushing toward a decision, the judge explains that Smith needs to understand how the different cases could affect one another. The preliminary examination is ultimately adjourned, so the defense can investigate the situation and make a fully informed decision.